Dictation will start in 5 seconds. Start. Defendant number 1 did not appear in the suit despite notice. The two defendants respondents, however, appeared before the trial court and filed separate applications under Order 37, Rule 3 of the Code of Civil Procedure for permission to defend the suit. The defendants' applications were based on a number of grounds, but we may only advert to the one that seems to have weight with the High Court. It was contended on behalf of the respondents that since the plaintiff appellant had got a promissory note executed in its favor by the borrower, defendant number 1, and had further made the borrower create an equitable mortgage in its favor by deposit of title deeds, they would be absolved of their liability in terms of Section 139 of the Contract Act. According to the respondents, their plea gave rise to a triable issue and they accordingly sought permission to file their written statements and contest the suit. The trial court, by its judgment and order, examined all the pleas, including the one based on Section 139 of the Contract Act, and found and held that none of the pleas raised by the defendants gave rise to any substantial defense against the claim of the plaintiff. Accordingly, it dismissed the petitions filed by the defendants respondents by order dated and proceeded to decree the suit of the appellant plaintiff for a sum of rupees 4 lakh along with cost and expense and future interest at the rate 10% per annum on the decreal amount from the date of filing of the suit till the date of realization. In appeal, the Delhi High Court, as noted above, set aside the order and decree passed by the trial court and directed it to allow the defendants respondents to file their written statement and proceed to try the suit from that stage. The High Court noted that relying upon Section 139 of the Contract Act, a contention was raised by the respondents that for recovery of its loan from defendant number 1, the principal borrower, the plaintiff, should have taken recourse first by either seeking to give effect to the promissory note or by enforcing the equitable mortgage. Neither of these remedies, which were open to the plaintiff, were taken recourse to, and the recovery was sought to be made straightway from the appellants. The High Court further held that the trial judge fell into error in holding that Section 139 of the Contract Act had no application to the facts of the case. According to the High Court, this was beyond the scope of deciding an application for leave done.